Very warm good evening to all. When we go to police station, the officer there record our statements. Now, whenever we say that our statement is recorded, we fear that we do not know what has been recorded. And because of my statement, my client or myself or somebody else will be punished for that. Is it so? Is it true? The answer to this you will find in the CRPC Criminal Procedure Code. Today we are going to discuss section 161, 162, 163 and 164. These are the important sections. You should know this, what happens when the police records a statement and what happens when the same statement is taken or taken as a deposition in the form of deposition before the magistrate. Now let's see. Let's read what is section 161. This is definition of 161. Examination of witnesses by police. Now here the examination does not mean that actually the police examines. Police record the investigation. It may be oral or written. Mostly during investigation, they take oral statement. And if they find substance, they write it down, which is under section 161. Any police officer making an investigation under this chapter or any police officer not below such rank as the state government may, by general or special order, prescribe in this behalf, acting on the requisition of such officer, may examine orally any person supposed to be acquainted with the facts and circumstances of the case. See, under section 161, it's a witness statement. Always remember. Such person shall be bound to answer truly all questions relating to such case put to him by such officer, other than questions the answers to which would have a tendency to expose him to a criminal charge or to a penalty or forfeiture. Such person shall be bound to answer everything, all questions relating to such case put him by such officer, other than, see, these wordings are very important, other than questions, the answers to which he would have a tendency to expose him to a criminal charge or to a penalty or forfeiture. So there will be a position where he is accused himself. So he will not be, he cannot be forced by the police to become a witness against himself. That is the meaning of this 161(2). The police officer may reduce into writing any statement made to him in the course of an examination under this section. And if he does so, he shall make a separate and true record of the statement of each such person whose statement he records. Now, if you read 161 very peacefully, you will understand that whenever you go to police station and the police makes an investigation about any offense, an FIR is recorded and you are called as a witness, it will be under section 161. And these statements are actually just what you are saying, and it is not on oath. Always remember, just because police force you or somebody has forced you at gunpoint, you are not supposed to speak anything which will put you to the criminal charge. You cannot be a witness. A person cannot be forced to become a witness against himself or herself. One. Number two, under 161, the police just record the statement that is before the police station. So this is not something that on which there will be punishment in the court. See, as you grow in the practice, you will know what is the statement under 161. If you have heard the my cross-examination videos, you will know that under section 161, statements are only for the corroboration or contradiction. Or you can suggest that you have spoken like this before the police station. So it is only for contradicting or to bring out the omissions on record. You will understand as you will grow in the practice what is 161 CRPC. Now next we go to the 162 CRPC. Now 162 CRPC. No statement to police not to be signed. Use of statements and evidence. No statement made by any person to a police officer in the course of an investigation under this chapter shall, if reduced into writing, be signed by the person making it, nor shall any such statement or any record thereof, whether in police diary or otherwise, or any part of such statement or record be used for any purpose save as hereinafter. There are exceptions to this also under section 145 of the Evidence Act. I'm not reading that. Now here I would like to tell all of you that whenever you go to the police station, the police knows the law, so they will not be taking your signature when you are appearing as a witness before the police. See, if you have any charge sheet or FIR copy, you will see that on the FIR the complainant signature is there, but you will never find any witness's statement signature on the witness's statement. If the lady under section 490 she complains against the in-law, her signature will be taken, but when her mother, father, neighbors, any friends will come as a witness before the police station for recording their statement, their signature will not be taken. So under 162, there will not be signature of the witnesses before the police station. So remember this. This is very important. And if there is a signature on the witness statement by mistake because of some reason that the police officer did not know, which hardly, I have never seen it happen. But if by chance it is there, then these statements are not valid under the law. Now, next we go to the section 163. This is relevant only for the purpose of that you should know it. No police officer or other person in authority shall offer or make or cause to be offered or made any such inducement, threat or promise as mentioned in section 24 of the Indian Evidence Act. Now here you have to see that the police officer cannot force, cannot induce, cannot threat, cannot promise anything that if you do this, I will do this for you. That is, if you give a statement as a witness, I will not accuse you, I will not make you accuse. This is not possible. This is what 163 says. But no police officer or other person shall prevent by any such caution or otherwise any person from making in the course of an investigation under this chapter any statement which he may be disposed to make his own free will, provided nothing in this subsection shall affect the provisions of subsection 4 of section 164. 164.4 is another section. This all section has to be read together, but we will try to understand the basics of 161 to 164. Now, the police officer cannot force, cannot threaten, cannot give induce. See, there are sometimes witnesses which are given inducement that if you do this, I will do this for you. Now, this kind of inducement is not allowed under law. Now, next we go to 164. This is the most important sections, and on the basis of this section, there is a possibility that accused or your client may get convicted. So it is one of the important sections of the CRPC. Recording of confessions and statements. See, the wording is again now it is confession and statements. Any metropolitan magistrate or judicial magistrate may, whether or not he has jurisdiction in the case. See, may, whether or not, he may not have the jurisdiction also, record any confession or statement made to him. Now, confession is always by accused or the criminal, and statement is by the witnesses. There may be a complainant in rape cases. She wants to make a statement that this person has raped me, made to him in the course of an investigation under this chapter or under any other law for a time being in force, or at any time afterwards before the commencement of the inquiry or trial, provided that no confession shall be recorded by police officer on whom any power of a magistrate has been conferred under any law for a time being in force. See, here the powers are exclusively given to the magistrate or the judicial magistrate. And secondly, he may or may not have the jurisdiction. There is a possibility the offense has taken place at Kandivali, and due to some reason, they want that statement may be recorded, but the magistrate not available at the Borivali court. Then it is possible that the state confession of the accused can be recorded before the judicial magistrate at Andheri court or some other court. That is from far away place also. That is the reason it is saying whether he has jurisdiction or not. So remember this is a confession by accused. if you remember, in Tada, there was a confusion by the Sanjay Dutt case about the statements. I would say Shiny Houses case, if you remember, just about 10 years back, he has 10 years, 8 years back. It was a rape case. In that case, also the complainant, the lady who complained about the rape charges, was brought to the Andheri court, and she was asked to give the statement under section 164. So in rape cases or serious cases, the complainants or the witnesses, the important witness statements are recorded under 164. There is a possibility, like in Tada, when Sanjay Dutt was arrested, he was taken to the magistrate to record his confession, because he confessed that I have committed a crime. So to bring more power to that statement, that he should not retract thereafter. See, he can retract, but then it will be a corroborative piece of evidence again. But this confession will be useful to the police, also to the court, while convicting the accused. So this is there 164. There is a one, two. There are five. This 6 subsections, but we have, due to positive time, we will not be reading everything here. But these are basic things about 161 to 164, and these are enough for you if you are running a trial. That statement, in nutshell, I will again summarize. 161 statement will be recorded before the police station, and 162 it will not be signed. 163 there will not be inducement, and 164 there will be it will be before the magistrate, whether he has jurisdiction or does not have jurisdiction. But then it's not only about witness, it may be witness as well as the confession by the accused. So simple it is. You have to just read it 3-4 times, and some judgments related to it. Now next we are going to read one very important judgment today. We will be reading part of it, but I would request all of you to read this judgment completely. It's a session trial from Pune, and one of the very important landmark judgments, and Supreme Court has taken this judgment also as a part of advocate on record examination. So it has been cited maybe 1,000 times by all the courts about the circumstantial evidence. So it is one of the important judgment. Ria will be reading this. There are 5 golden principles governing cases based on circumstantial evidence. The case name is Sharad Birdichan Sarda versus State of Maharashtra. This is from Maharashtra, Pune. I will ask Ria. Ria, can you read? Please unmute yourself. Ria, kindly unmute yourself.
Yes. Yes. Yeah. In Sharad Birdichan Sarda versus State of Maharashtra, 1984, 4 SCC 116, the bench of S. Murtaza Fazal Ali, A. Varadranjan, and Sabyasachi Mukherjee, JJ, laid down the following 5 golden principles, that is, the punch-sheet of the proof of a case based on circumstantial evidence. The circumstances from which the conclusion of guilt is to be drawn should be fully established. There is not only a grammatical but a legal distinction between may be proved and must be or should be proved. It is a primary principle that the accused must be, and not merely may be, guilty before a court can convict, and the mental distance between may be and must be is long and divides vague conjectures from sure conclusions. 2. The facts so established should be consistent only with the hypothesis of the guilt of the accused. That is to say, they should not be explainable on any other hypothesis except that the accused is guilty. 3. The circumstances should be of a conclusive nature and tendency. 4. They should exclude every possible hypothesis except the one to be proved. And the last, there must be a chain of evidence so complete as not to leave any reasonable ground for the conclusion consistent with the innocence of the accused, and must show in all human probability that the act must have been done by the accused.
Yeah, just wait. I'll be sharing little more from the judgment.
Yes.
Here, these are a few paragraphs which are very important. I would request to read this. Just a minute, Ria. I would like to say something
Yes.
here. See, this is if all of you can see, this is a Supreme Court judgment. Sharad Birdichan Sarda or Sarda versus State of Maharashtra. It was delivered in 17 July 1984. And here, Ram Jethmalani sir was also there. So do read it and how see the trial was run and accused was actually acquitted later on. Just please read. I'm sharing the important paragraphs. Just a minute. Ria, start reading from here, page 947.
Yes, ma'am. Page 947. Circumstances of the transaction resulting in his death. This clause refers to two kinds of statements. One, when the statement is made by a person as to the cause of his death, or two, when the statement is made by a person as to any of the circumstances of the transaction which resulted in his death. The words resulted in his death do not mean caused his death. The expression any of the circumstances of the transaction which resulted in his death is wider in scope than the expression the cause of his death. The declarant need not actually have been apprehending death. AIR 1964 MP 30. Page 947. The expression circumstances of the transaction occurring in S32 clause 1 has been a source of perplexity to courts faced with the question as to what matters are admissible within the meaning of the expression. The decision of the Lordship of the Privy Council in Pukala Narayan Swamy versus Emperor IR 66, IA 66 sets the limits of the matters that could legitimately be brought within the purview of that expression. Lord Atkin, who delivered the judgment of the board, has, however, made it abundantly clear that except in special circumstances, no circumstances could be a circumstance of the transaction if it is not confined to either the time actually occupied by the transaction resulting in death or the sense in which the actual transaction resulting in death took place. The special circumstance permitted to transgress the time factor is, for example, a case of prolonged poisoning, while the special circumstance permitted to transgress the distance factor is, for example, a case of decoying with intent to murder. But the circumstances must be circumstances of the transaction, and they must have some proximate relation to the actual occurrence. Page 948. Circumstances of the transaction is a phrase, no doubt, that conveys some limitations. It is not as broad as the analogous use in circumstantial evidence, which includes the evidence of all relevant factors. It is one, on the other hand, narrower than the res gestae. Circumstances must have some proximate relation to the actual occurrence, though, as for instance, in the case of prolonged poisoning, they may be related to dates at a considerable distance from the date of actual fatal dose. Page 948. The Supreme Court, in the case of Shiv Kumar versus State of UP 1966 Criminal Appeal RSC 281, has made similar observation that the circumstances must have some proximate relation to the actual occurrence, and that general expression indicating fear or suspicion, whether of a particular individual or otherwise, and not directly to the occasion of death, will not be admissible. Page 949. The clause does not permit the reception in evidence of all such statement of a dead person as may relate to matters having a bearing howsoever remote on the cause or the circumstances of his death. It is confined to only such statement as relate to matters so closely connected with the events which resulted in his death that may be said to relate to circumstances of the transaction which resulted in his death. IR 66, IA 66. Circumstances of the transaction which resulted in his death means only such facts or series of facts which have a direct or organic relation to death. Hence, statement made by the deceased long before the incident of murder is not admissible. 1974 CLJ MP 1200. Law of Evidence by Ratan Lal and Dheeraj Lal, 1982, reprint, page 94. Circumstances of the transaction, general expression indicating fear or suspicion, whether of a particular individual or otherwise, and not directly related to the occasion of the death, are not admissible. IR 66, IA 66, 18, part 234, page 95. Circumstances must have some proximate relation to the actual occurrence and must be of the transaction which resulted in the death of the declarant. The condition of the admissibility of the evidence is that the cause of the declarant's death comes into question. It is not necessary that statement must be made after the transaction has taken place, or that the person making it must be near death, or that the circumstance can only include the acts done when and where the death was caused. Dying declarations are admissible under this clause.
Thank you.
The
Thank
alleged...
you. Thank you.
Thank you.
Thank you. Very well read. You got good pronunciation. Now, see. If you see, this judgment is of 1984 of the Supreme Court, and it has referred many old judgment as well as, and if you see last 5 years judgment also of the Supreme Court, in all the circumstantial evidence where there is a circumstantial evidence, Sharad Birdichan Sarda's case, you will find always the mention of this case. And this is about the section 32 of Evidence Act, which is about the dying declaration. Now, this was a case of a lady who died because of the poison. Now, there was only circumstantial evidence, and somehow when the matter went to the Supreme Court, the accused was acquitted, and before High Court also, one of the accused was acquitted. So it is one of the case where you should read what kind of judgment it is and how the matter was examined under section 1313, how the examination of accused under section 313 of Criminal Procedure Code, circumstance not put to accused to explain, cannot be considered for conviction. I have explained the stages of the trial, and there is a stage where a statement of accused is taken. Now, under section 313, this was the judgment in 1984. We said, now also we have a lot of judgments. We said, if there is a circumstance which is not put to the accused to explain, which has come in the deposition of the witnesses or the complainant, then it cannot be considered for the conviction. He cannot be convicted. So section 313 is also very important statement of the accused, because whenever we see section 313, it is a statement of accused, why we should look into it. But if it a matter is of conviction, you should see what questions are asked to your accused. So this is very important judgment. I would urge all of you to read it whenever possible. Now next we move to another section. It is about the POSH, an act which is useful to the women who are working women especially. You all have heard about the Vishaka guidelines. Vishaka guidelines are the guidelines given by the Supreme Court for the women who are at the working place. You all must have read about the Bhauri Devi's case. But now, see, 8 years back, sexual harassment at a workplace, this act has been passed by the parliament, and once it is legislature has a main has taken out an act. So the Vishaka guidelines will be only for academic interest, but you should know Bhauri Devi's case as well. She was a Satin who was raped by the some higher class people, and they said on the lower class, their police also said the lower class, higher class of people cannot rape the lower class lady, and that way the FR was not registered. But somehow this matter came up in the newspaper, and slowly the complete country came in support of the Bhauri Devi, and Supreme Court, there were a lot of petitions, and because of that Vishaka guidelines came into the came for the women's help. And there was a, because of the Vishaka guidelines, there was a need for a committee which has to be established if more than 20 or 10 minimum people are required, depends on the private or the public sector places of the workplace. Now I'll be reading it. This article little critical, but then we should know what is it. Sexual harassment at the workplace, a relook at the POSH Act on its 8th anniversary. There are many procedural aspects in the POSH Act that may need to be relooked at in light of experience of the past 8 years. It is written by Nageshwar Rao, Kulipati and P. Sridevi. The Sexual Harassment of Women at the Workplace, Prevention, Prohibition, Redressal Act 2013 came into force on December 9, 2013. Though it was passed 16 years after the Supreme Court's Vishaka judgment, it was a tremendous step forward in concretizing the basic rights of women at the workplace. The Act will complete its 8th anniversary in existence in December 2021, and this would be a good occasion to ponder on the journey of the legislation and take a look at some of the more obvious gaps. To start with, it becomes very obvious to anyone who has read Vishaka that the gist of the POSH Act seems like a cut and paste from the judgment. Let's not look at it from the critical angle, but let's understand it. What does the author want to say? And that we will be revising this act. The legislature chose a safe path and just adopted what the Supreme Court enunciated in the 1997 verdict. See, verdict means judgment. See, when we read this kind of articles, our vocabulary is also polished. One obvious fallout of this was that two untested entities came into vogue, the internal committee and the local committee. Section 30 of the Act gave power to the government to remove any difficulties in giving effect to the provisions of the Act. The Ministry of Women and the Child Development had published a handbook on the POSH Act in November 2015. If anybody can find this handbook of the POSH Act, which was published in November 2015, I would request put in the group. Along with this said handbook, it would have been very helpful to the fledgling ICs and LCs, the internal committee and local committee. If the government had issued some clarifications on appointment of IC, conducting inquiry, etc. However, sadly, that opportunity was not utilized and allowed to expire. The judicial review of the POSH Act by various high courts and Supreme Court has provided some clarity on its various provisions. The judiciary continues to bear the torch for women's rights by upholding the right to dignity at work and has steadfastly refused to dilute some of the provisions of this law on grounds of hyper-technicality or procedural infirmities. LS Cebu versus Air India Limited, another. This is also one of the judgment on POSH. The principal areas that broadly call for a relook are as follows. The historical evolution of the protection of women from sexual harassment was in two broad stages. The initial one was the more obvious, quid pro quo, but it took some time for the state and the courts to recognize the more subtle one, a hostile work environment. The definition of sexual harassment outlined in Section 2N of the POSH Act, read with Section 3.2, subsumes these two broad categories. In the USA, the two categories follow different contours and try to address different aspects of the same problem. The courts in India have been treating the two as subcategories of the prohibited conduct of sexual harassment and have applied a similar set of rules for eliciting whether sexual harassment is present in a given case. While this removes the procedural difficulties faced in the USA, the objective woman test, etc. The critical piece which has got omitted is that while third party not directly facing sexual harassment could also raise a claim of hostile work environment in the USA, this may be difficult under the POSH Act due to the offending actions not being directed to such third party. See, that's the difference between the US and Indian laws. While this approach simplifies the inquiry into sexual harassment, it certainly prevents anyone other than the person at whom the conduct is directed to raise a complaint. While it may not be impossible to read into the inclusive definition of sexual harassment the rights of a third party who may have suffered indirectly due to the actions of the respondent, the course would be tortuous and may take an unduly long time to evolve. For example, respondent intimidating or physically harassing a co-worker of the complainant, not directly interacting with the complainant, would certainly be traumatic for the complainant, hence may need to be addressed via hostile work environment if the victim is not coming forward to raise a complaint. Second, the definition of workplace needs a relook. The discussion currently revolves around the judicial expansion that has occurred in relation to workplace under the Employees Compensation Act, 1923 ECA. However, most, if not all cases under the ECA are one-time incident, unlike sexual harassment, which usually involves a series of incidents that can happen from anywhere. Thanks to the modern technology, to take few examples, a woman is interviewed in a company and thereafter the male interviewer keeps proposing to her. In this case, the incidents of proposing may have been done by the respondent from his home. And when the complainant was also at her home, when she received the messages, chats or calls. So this will be workplace or not is difficult, but it has not been clarified. It is left to the court's concerns. A few co-workers are traveling in their private time to attend the marriage of one of their co-workers. One of the male co-workers misbehaves with the complainant. Now, this will not be a workplace.